You are watching DHTV from California State University, Dominguez Hills.
Hi, I'm Dr. Pamela Kreiser, and welcome back to NCR 525, which is our course on mediation. Today we have a special episode where I'm going to spend the entire time interviewing Kathy Shimizu, and she is a graduate, actually, of our NCRP program here at CSU Dominguez Hills. She graduated in 2007, so she'll bring her 11 years of experience since that graduation date to tell us about her experience as a family mediator. She mediates also in Superior Court. She is a practitioner as well as a trainer in really all aspects of mediation. So welcome to the show, Kathy.
Thank you for having me.
My pleasure. So it's fun to have you as a graduate of our program.
It is.
And to really have a chance to kind of talk to you about your experience, especially in the area of the family court. Mm-hmm. Now, as you know, it's not something that I have expertise in, so I'm excited that you will be the teacher today.
I'm looking forward to it.
Okay, good. So let's start with your background and training. So I know you went here, but I don't know the other parts of your background.
Well, I actually started out as a high school science teacher, and we moved to Boston for my husband's job, and I took some time off from working outside the home because my kids were young, and I started volunteering as a court-appointed special advocate with working with abused and neglected children. And my role there was to gather information for the court about what was in the best interest of the children so that they could make good decisions about, the child's placement and working with the families. And through that process, I learned that the court is not good at being a place to take family challenges to. Because some of these kids that I was working with, they actually ended up staying in foster care for periods of years while the court tried to sort out how to resolve the problems. And it wasn't that there weren't people trying to do good things for these children. You had the foster parents, you had the parents, you had the social worker, the teacher, the therapist. Everybody had an attorney, and yet it didn't work. And that's because nobody was working together.
So were you the thing that made that work together, like communicating?
No, my
parties?
job was just to interview everybody. I was just providing information to the court about what everybody thought, and then what would be the best thing to move forward with the child. And at that time, I actually had one case where I ran across in my investigation. I talked to somebody who had participated in what I now know was a family group conference, where what they did was they brought everybody together in a room and they talked about the child's needs, everybody face to face. Okay. And I was just thought, that's the solution. Everybody's trying to do good here, but nobody's communicating together, and so nothing happens. Right. And then at that time, I didn't even know what mediation was. Okay. And I started doing some research, found out about mediation, went and took a basic mediation training, which then led me to doing small claims mediation.
And that was in a different state?
This was in Massachusetts.
Okay.
This was in Massachusetts. Okay. And then shortly after, we moved back to California. Okay. And at that time, I just focused. I loved mediation, and I got involved with the volunteer program in the courts here in Orange County as a volunteer, and ended up going to Dominguez Hill to get a master's in mediation, and then ended up working in the field. So yeah. Okay.
So fueled really by that passion in the family court, it sounds like.
Right.
Or propelled that way.
Right. Well, just wanting to see good things for children.
Yeah.
I think that was my original interest was seeing good outcomes for children, and just seeing how the court really exacerbated the situation and didn't make it better. So,
even though trying to be better.
Yeah, absolutely.
Which is interesting.
Everybody was doing their best to address the needs of the child, and it just wasn't happening.
Yeah, but that's very interesting commentary on people trying to do good, but not having either a system and or method in place to maybe accomplish that good.
Right, and I think a lot of it boils down to difference from, the courts are inherently adversarial.
Yeah.
And trying to work in an adversarial system where there's black and white, right
Win,
or
lose,
wrong,
yeah.
Blaming and everything, and then, taking it out of that environment and putting it into a situation where what is the best that we can do, understanding the situation as well as we can.
Sure.
And that collaboration
Right.
is a whole different
Yeah.
experience and produces much better outcomes.
Right. So tell us about your current role.
So currently I work for OC Human Relations in Orange County, and we are a nonprofit agency that really focuses on diversity and inclusion in Orange County, trying to help those that don't have a voice find a way to work within the county. A piece of that our agency deals with mediation and conflict resolution, and that's the portion of it that I've been involved in. And I started out there doing intake in their small claims program in the civil court, and when the opportunity arose to do family, they started to do a program in family court because of the interest that I had in children and family dynamics. That was kind of a natural spot for me to pursue, and I worked to develop a program in the family court based on what their civil program was.
Okay, so I know you do the training for family mediation through that agency. What else? How else do you spend your time?
So I do. So my current job now. Recently, I became the coordinator of the entire program. So now I oversee the staff, the whole mediation staff. So that the civil court, the family court, and then we also do some community mediation.
Okay.
Where individuals come to us directly, mostly learning about us through the internet, and ironically, I think that's where our agency started out. But what happened over the years is it kind of got pulled into the court, and so in the court we're doing mainly in-stage mediation.
Yeah.
And so now that I have more of a leadership role in the program, my hope is that we can look at going back to those roots of looking at mediation first, and trying to provide opportunities for people to do mediation before they get sucked into that court system, where then everything just gets complicated and escalates in terms of the conflict.
Right. Okay. So maybe you've answered this already. Tell me about your passion about divorce and family mediation. What's at the heart of that for you?
I think it's interesting because I think the reason that I initially went into it is probably different than my passion now. It's evolved over time, because I think that I went into it with I wanted to have an impact on the lives of children.
Sure.
That's what had motivated me to work with abused and neglected children in the first place. And what I came to realize somewhat is that that's not really what mediation is all about. I'm not there as an advocate.
Right.
But it shifted into the role of empowering people to make their best decisions in very complex, challenging, emotional situations that get in the way. And so what I love about it now is it really is helping them, come up with the best possible solution for, their situation.
Right.
And I just really enjoy doing that kind of work.
So you said complex, challenging. I don't know if you said emotional, but we could throw that in there. Is that how you would describe that family court environment?
Oh, absolutely.
What are the challenges associated with that being there?
Well, and I think that when we're talking about doing divorce mediation in the family court, it is probably some of the most challenging mediation, because the people that that are there, they're there because they can't work together, and there are emotional issues that are in the way, and we call them high conflict couples, and these are couples who statistically the court says that they use about I think 90% of the court time.
Oh, really?
Isn't that interesting? They're back at court for every issue.
Oh, right.
You know,
Of
because when
course,
somebody
yeah.
gets divorced, their case doesn't close. You know,
Right.
as long as there are children, the court case stays open.
Sure.
And these people, you know, I can think of a case where I had saw this couple probably 8 or 9 times over a period of 2 years, and it was like every little thing. They, you know, that was where they went when they couldn't work something out. They went to the court.
So is it like custody adjustment, like visitation, like?
With children, yes. When you're looking at parenting plans, you know, it may be, you know, where is the drop-off going to be, or
Okay.
you know, what school is the child going to go to, or you know, the parent isn't calling me back when I leave them 4 messages, and so
Yeah.
literally people go to court.
Right,
Then-
so they're going to court and they're going to court over each thing.
yes.
So are they alternatively offered a way to, I mean, you said you're kind of dealing with those high conflict couples more often in mediation. So how do you get them in your mediation versus in the court?
So that's what the program that we have launched in Orange County, which is a fairly unique program, so I'm kind of proud of it because you don't see many of these across the country where you have the opportunity for you know, parents to engage in you know, mediation as opposed to seeing the judge.
Right.
There, and I want to stop for a second because there is the court. The court actually in California was one of the forerunners for putting in place child custody mediation in the early 1980s.
Okay.
They were one of the first 3 states to start doing that. And so there's actually a law in California that says if you have a contested matter concerning custody and visitation, you have to attempt mediation before you can see the judge. Okay, so that's in place, and there are court mediators who handle those cases. There are some challenges with that, one of them being just that there are so many cases. And
Oh, yeah.
so the mediators don't have a lot of time to spend, you know, on each individual case.
Right, and just to clarify, so those mediators are employed by the courthouse, not in your program?
That is not our program.
Okay.
So that's been in place across California since the early 1980s.
Okay.
So what's different about our program is that, one, we're not limited to custody and visitation. We can deal with any issues that divorcing couples or individuals who are there for parentage cases come into the court for. So property matters, child support, spousal support, attorney's fees, all those other
Okay.
things. We handle all those issues. So that's one difference with it. And then, and so what we do is the judge will refer a case to us if they think that mediation could be helpful.
To you, not to the court mediators, or they've already been
most
there?
of the time they've already been there.
Okay.
Okay, they've already been
Okay.
to the child custody mediators if there's a custody issue involved in their case.
Sure.
And so now it's just, you know, and there's another difference is that they are there that day usually to have a judge make a decision when they come to see
That's
us.
their expectation.
Is that if they don't, if the judge sends them out to meet with us, and if they don't reach an agreement, then they'll come back in. The judge will hear their arguments,
Sure.
and make a decision. And so we're kind of that last stage attempt to give them the opportunity to try to work through it in a collaborative process.
Sure.
Yeah.
And so what would you say of the court cases that go into family? They're required, obviously, to see the court mediators in a custody situation. How many come to your program? If there were 100 cases, do 50 come to you guys? Do
It's
20?
much smaller than that. You know,
Okay.
if you look at the number of cases, and I honestly don't know the number of cases that go through the family court in Orange County currently, but I know that it's thousands a year. We handle probably about between 350 to 450 cases a year. One of the things that limits us is our ability to be there. You know,
Oh,
the
sure.
funding level. We can only provide mediation services 3 mornings a week.
Right.
And so that limits the amount of mediation that we can provide.
Okay.
Yeah.
So then, but that's like maybe a 2-hour mediation or a 4-hour mediation, right?
Well, our program we'll do up to 8 hours of mediation.
But times 400 mediations. I mean, the
Right.
amount of court relief
Right.
incredible.
It's significant, and the judges are extremely appreciative.
Yeah.
In family court in Orange County, there's about 17 family court judges. The majority of them do send us cases. And I think that one of the things that we'd like to do is to educate them a little bit more on the types of issues that they can send to us, because it's interesting how one judge may send us all of they're called mandatory settlement conferences, where that's the last chance they have to try to work things out before their trial date.
Okay.
Others send us their requests for orders when somebody comes in and they're just trying to make a change on the placement in the school. But so different judges are using us in different ways.
Got it.
Because they see that as that's a way that we can be of value to them.
Right.
So I really, hopefully over time, we'll start to be utilized even more. But part of it is, what's our capacity to provide mediators, because we have one staff person on site that supervises that program, and then volunteer mediators who do the casework.
Right. Okay. So educate the judges. I guess it's all fine-tuning the system, really.
Right. Right.
Get the better cases or more suitable cases, and then keep working on expanding the volunteer.
Well, and of course it's my bias, but I think we can. All of those are suitable cases.
Well, yeah,
for mediation. Is that
do we have the resources?
That
I guess, is the question.
we can do a lot more. One of my challenges with it is that, like I said, we're at the end stage. We get mostly the high conflict couples, which are the hardest ones.
Oh, sure.
To mediate, and that being said, about 68% of the time, the parties walk away with at least some agreements. They may not resolve all the issues, but they've resolved something, before they go back to see the judge.
Right.
And in an ideal world, what I'd like to do is have access to the parties when they first come into court.
Sure.
Because as I pointed out kind of in my history of how I came to mediation, is I really think that adversarial system that they're being run through really escalates the conflict and contributes to the high conflict that the parties have in place when we finally get them in mediation.
So am I hearing you say they become more entrenched in their position?
Absolutely.
Okay.
And also feeling they're more hurt, they're more disillusioned, they're fed up with the system as well as each other, on all kinds of levels. They're just in a much more difficult place, which is very different than if you look at private mediation. Where when somebody goes out and hires a mediator for their divorce, it's a very different experience, because one, those people are looking for mediation, so that automatically tells you that they have some willingness to work together. They don't feel they're at a place where they have to do battle yet.
Right.
And that experience of doing private mediation is very different than the mediation that we do in the courts.
So it's so I guess what I hear you saying is when they go to private mediation, people aren't necessarily at the end of their rope like they are when you might see them at the very end.
Right. And so how, as a mediator, when you're coming into it. When I do a mediation with someone who's just starting a divorce case, I approach it very differently than I do when I'm in a court setting and they're there for a trial.
Okay, so then what's the difference? I have to ask you that. If you approach it differently.
I think that and it depends on. Oftentimes, when you're in court, it's not the entire divorce. They're there for very specific issues, like it may be that they can't figure out, just their property division. It's wherever they're stuck. So you find out where they're stuck and what it is that they need to work on, as opposed to when you're in private mediation. Getting married is very easy. Getting divorced is incredibly difficult. Yeah. And the reality is that 80% of individuals who are getting divorced are not using attorneys today.
Really?
In our courts in Orange County. Yes.
Okay, so they're not using attorneys. Who are they?
They're representing themselves.
Okay.
Which navigating the divorce process is very challenging.
Yeah.
a good example of that is that if somebody is pro per representing themselves and they have a complete agreement, they're agreeable on all of the issues that have to be decided, then the packet of forms that they have to submit to the court to have that entered as a judgment, it's about 40 pages long.
Yes.
So navigating that is a challenge. And I think that, when you're a private mediator, that's a very important part of the role that you play as a mediator.
Right.
And it's kind of something you have to be a little bit careful about because, you want to guide them, educate them about the process and lead them through that process, but being sure that you're not influencing the decisions that you make along the way.
Which is all of mediation.
Right, right.
So when we talk about this area of family court, are there characteristics that you think are more ideal? Like what makes a good family mediator versus a not ideal family mediator?
I think that one is training. I think that it takes a lot of training to develop the context of the mediation and to know, what it is that they're navigating and to be able to know what kinds of questions to ask. Because there are so many laws that that determine what can and can't be done in a divorce. And while in mediation people have choices, but it's against that backdrop.
Okay.
And so, for example, you can't get divorced without, having, if you have children, having a parenting plan and having, a decision about child support and spousal support and listing all of your assets and debts and dividing them up. So those things have to be done.
Right.
It's not just we want to get divorced and go in and sign the papers and it's done.
So is an ideal mediator, you would say, is one who understands the law but can facilitate the law, or?
One who understands the decisions that have to be made based on the law.
Okay.
Enough to be able to, because the parties don't.
Right. So it's like you have to bring this structure.
Right. And so and bring that context to they're looking for that. Unless you're doing a case where both sides have attorneys, and then that's the role that they play. But as I said, many times people don't have.
80%. That's so interesting to me.
Yeah.
And so you have 80%, but then the amount of educated individuals in that 80% is probably not very high.
No.
In terms of what needs to be done or how to fill out the paperwork properly or whatever. Right. Yeah, that's interesting.
And that was probably, for me, the biggest challenge of going into family mediation because, I had a lot of experience doing civil court mediation. And then when I wanted to go into family mediation, I went and took a basic divorce mediation training. And I thought, okay, this is what I need. Now I'm going to be able to do divorce mediation. And a very reputable training program that I went to. And it was excellent.
Yeah.
The problem was it really focused on mediation, which I was already an experienced mediator.
Right.
What I needed to know was, how to navigate that context. And so, and that took me a long time to develop. I can remember, I don't know if I should even admit this, sitting in, when we started in the family court, sitting in the court, one judge, Judge Bells, I have to give him a lot of credit, kind of gave us the opportunity to come into his court and do mediation. At the time, most judges and attorneys feel like, well, if you're not a family law attorney, how can you do mediation?
Oh, okay.
There was a tremendous pushback on that, how can you do this when
I still kind of hear that actually sometimes,
And so he, gave us the opportunity to do it, but I was relatively new, and I can remember sitting in the courtroom and thinking, oh, please don't give us a case, please don't give us a case, because I was unsure. I didn't feel like I had the knowledge base of this subject matter to be able to navigate it and not make mistakes.
Right.
That type of thing. So,
right.
I gradually, and so I read a lot. I went and took a paralegal family law course, so I over time and through trial and error and making mistakes,
Yeah, which happens.
I filled in those gaps. And so, when in the divorce mediation training that I do now, it is really designed more for mediators who need that context. And so I do a lot of training mediators around family,
Okay.
How to mediate family law cases specifically.
Okay, so that's the training that you facilitate.
Right.
I think 2 times a year, is
We
that
do that
right?
twice a
And
year.
when's the next one coming up?
It's in the middle of July, starts
Okay.
July 14th, and
Okay.
we do that twice a year. And, part of it is to train volunteers for our program.
Sure.
And then it's probably usually about, probably 60% of the people who take the training are not volunteers. It's family law attorneys who
Sure.
really want to incorporate mediation skills into their practice. It's married family therapists who
Okay.
want to use mediation, financial advisors who work with divorcing couples, who want to understand how to cope with the emotional elements,
Yeah.
develop some skills around doing that. So it's a really fun group to work with because it's a lot of
Yeah, a lot of different ideas in the room.
Different people coming from different places, but yet those mediation skills that they get, whether they intend to be a mediator or just incorporate those skills,
Right.
it makes it's a benefit. So it really is a win-win.
I like that. Is that, so when we talk about getting started, let's say somebody wanted to go into family mediation, and I don't know if that means opening up a private practice ultimately, but where would you say that's a place to start, like to go to a training like that, or what would you recommend?
Well, depending on where they are currently in terms of their background, but I think that really is a good place to start because the reality right now is, at least, and I can speak specifically to Southern California, in terms of job market and opportunities for family-focused mediators. Most of it is private practice. There are not a lot of, there are the court mediators, but they have a very small number of mediators, and they require that their mediators actually have backgrounds, master's degrees in psychology.
Okay.
Or because they're mediators, they do both mediations and investigations.
Oh, okay.
So not in the same case.
Yeah, but both roles.
Right. So
Okay.
they're not just mediators.
Interesting.
And so those are actually the only direct mediation jobs
Right.
that I am aware of, in the area where we live.
Okay, so you talked about going into private practice. Let's say that was my goal. What would be the steps to get there?
My recommendation, I get calls like this all the time, is would be to get that basic mediation training.
Sure.
But that's only the beginning, because
Yeah.
no 40-hour training is going to prepare you for the whole experience.
Yeah.
I really think the best thing going is to get involved with a program, to look for a program like ours where you can do volunteer mediation that involves a mentoring component to it.
Okay.
So that you get, you get to practice your
Sure.
skills and have coaching. That is an invaluable experience, and I have to say, I have a master's degree.
Right.
I have attended countless trainings.
Sure.
Read many, many, many books.
Yeah.
And the most valuable experience that I've had in terms of developing my mediation skills is mentored mediation experience.
Okay, so tell me what that looks like. So let's say I become a volunteer in family, which I'm currently not, but let's say I did do that. Do I have someone doing the mediation with me? Do I have someone watching me and then commenting? Like, what does the actual mentoring component look like?
Well, I can speak to our specific
Yeah.
program, and the way that we do it is when somebody first comes into the program. First of all, we have a requirement that they have had basic mediation and family mediation training.
Okay.
that they are an accomplished mediator, that they have done 25 mediations. Because we want, as I said, I think the context of doing family law mediation is complex, so we don't want to be training them to be mediators too. So we only accept already experienced mediators into our court program. And then what we do is we have them start out just observing court. And honestly, I learned a tremendous amount.
Yeah.
All those hours when Judge Bells didn't give us a case, sitting in his courtroom listening to cases.
Right.
That's invaluable.
And that honestly is true about any mediation, in my opinion, is just sitting and watching that system, the uniqueness of the system, how it functions, how it functions in place of mediation, so that you can see the distinction too.
Right.
Like the whole part is educational, I think.
And the types of issues that there are, so the first time I'm sitting in court and I hear Watts credit, I go, oh, what's that? And from what the discussion in court, the attorneys are arguing about it, but you don't know what it is because they know, the judge knows, and nobody's explaining things. So I immediately go and I look up what's a Watts credit. And, and that's a reimbursement for money, after post-divorce. But so you learn about those things. So we have people spend time in court. Then we have them start just observing mediations, and when they do a mediation observation, then they sit down with the mediators who did the case afterwards and ask their questions. What they saw, what did they, what was confusing to them, and so they start learning from that. And then after they've done some observations, then they start getting involved in the mediation. In our program, to the extent possible, we always use a co-mediation program, a co-mediation model, regardless of whether it's two experienced mediators or an experienced mediator and a new mediator, because that's also very helpful in family mediation.
So you mean two mediators as whenever it's possible?
As a team.
Yeah, whenever possible.
Yes, that's
sometimes
always
that's not possible, but ideal.
Right, that's always our preferred model, and particularly in family, just because there is so much to it. And then as a co-mediator, then they start doing more and more of the mediation work, and then they gradually get to where they're the lead mediator, but they're supported by an experienced mediator, and that helps them with developing their mediation skill. Then we also require that in order to become a lead mediator in our court program, that they take some classes that we offer on special topics. For example, with child support, California uses a child support calculator, which is a program. And so if you're going to be mediating child support, you need to know how to work with that program. And so we train our mediators how to utilize the program and to do mediations, with that in their mediations.
So still do a neutral, facilitative mediation with special knowledge.
Right.
So that's very interesting to me.
Right.
We don't see that as much of an issue in small claims and even civil harassment, to the extent that I think it appears in family.
Right.
That there's certain protocol. What is that challenge for the mediator to like know a law and hear an idea that is against the law? Like, what do you?
Well, and that's probably one of the biggest discussions that we have with our mediators is, what we refer to as the unauthorized practice of law, is when you when you give your opinion about how the law applies to their case. And
is that allowed?
No, absolutely not.
Okay. I wanted to clarify.
For a mediator, because when a mediator, and even if you're an attorney mediator, it's not allowed. Because a mediator, otherwise you're acting as an advocate, an attorney
totally
for
agree.
one side or the other if you're rendering an opinion. So that's one of the challenges, because how can people make their best decisions if they don't know? Sometimes they want to know what the law says, or sometimes they're talking about doing something that really is way outside of what the law would do. So is that, but they're in agreement.
Yeah, I know. That's what I'm thinking.
And it has, So what do you do as a mediator?
Right.
So one thing that we do is we always emphasize that, family law is very complex, and that in mediation, this is, a place where they're making their decisions based on their sense of fairness and or needs about, what works for them. But we recommend that they consult an attorney either during
Right.
the mediation process or when they reach an agreement to, to make sure that they understand, this may not be what they would end up with in court, and that that's what they want to do.
Right.
So we always make that recommendation. Sometimes we will even, when there's topics, if they want, we can bring in some, the California State Bar produces some informational sheets
Okay, so
that
that's
are very basic, like what is community property, what is separate property.
Right.
And and you really can't have a discussion around division of assets without an understanding of community and separate property.
So you set it up with like saying here's information for both parties as we start this conversation. Is that how you facilitate it?
You can do that. You can provide them with resources. You can also, and it's okay. And this is, again, where it's that, finding that fine line. Where's the boundary between stepping over? You can you can share information, basic information about family law. And so, I normally in a mediation, I will tell them what the definition of community property and
Sure.
the definition of separate property. Same thing with what is, joint custody or legal custody and physical custody. What are those
Okay.
as defined by the law? But then I don't tell them, well, because you're doing this, it should be joint custody.
Right. That would be stepping over the line.
That's where you go over the line.
Okay.
And that it is a challenge for mediators,
Oh,
to
big challenge.
navigate that.
Yeah.
And so within our group of mediators, we have lots of discussions about those. And one of the things that over time, what we've developed is kind of, and I've really struggled with that as the person who has developed the program, how do we navigate that? Because they have to have some understanding to have the discussions. And so we have gone to providing information. So we have a binder about this thick that we have, at the court that our mediators take into their mediations
Sure.
with them. And for example, one sheet in there is an IRS description of, what is what are dependents, what are
Okay.
filing status.
Right.
That divorcing couples can use, because a lot of people don't have an understanding of those, and in order to determine child support, you have to make decisions about who's going to claim the dependents, the children.
Sure.
And so so we give them that information, that handout, and we discuss it with them.
Yeah.
We have them discuss it,
Right.
and then they can make their decisions, which then move them forward in the mediation process.
Yeah, that's very interesting.
So-
Okay, so there's an educational component, and I guess what I hear you saying is as long as you set it up as here's the information, and then what you want to do is what you want to do, and you're not connecting the two,
Right.
then you're
Right.
maintaining that neutrality.
Right. And I think that that's something that a mediator has to figure out how they're going to do that. And I know some mediators who, private practice mediators, who will, before they start the discussions, they will give a little mini lecture on,
I could see it. I mean,
here are the basics
Yeah.
of community and separate property.
Right.
Here is, what how the court views child
Right.
support. Important, information about that.
Yeah.
And you're always free to do what you want in mediation, but here's that information, and then you move into the discussion. So
Yeah.
that's another way of doing it.
So that, of course, reminds me of something we talked about before the show started, and that is role definition. And one of the comments that you and I agree upon highly is that the mediator must know his or her role, maybe foremost
Right.
in some ways.
Right.
Talk about how that relates there with the law and practice.
I mean, I think it's, again, just that it's how do you separate, the education that you need to provide, and it can even be a discussion of, how are they going to get that? And maybe it's that they're going to go out and consult outside attorneys and then come back. More if you're in the middle of a mediation and the sticking point comes up and they have different views on what the law says. And I can't tell you how many times I've had a mediation where, well, I talked to so-and-so who is an attorney and they told me this, and then, well, I talked to so-and-so and they said this, and they're 180 degrees apart.
Right. And I feel like we have that in every court, actually.
And, and again, that goes back to that adversarial approach because, there is the law, but there's always some gray. In terms of how it's interpreted. And that's what people pay attorneys a lot of money to argue about in court, is that grayness.
Sure.
About, particularly say you have a house where it was purchased before marriage. Well, then how much of it is community property? How much is separate property? Is the, equity that builds up, is how does that play into it? And there are laws that spell that out.
Sure.
So, figuring out how they're going to get the information they need to be able to move forward in making decisions. And so I think oftentimes you mediate that.
Which is interesting.
Yeah, you mediate how to get to a point where they can make a decision. And recognizing that, it's not my role as a mediator to push them in one direction or another.
Right. Okay, so let's talk about the ultimate gray area, emotions. I don't know if we'd say that's the ultimate gray area, but it seems like the area that, so when I think about family court, when I think about the kinds of cases, and I certainly deal with emotion in the small claims and civil harassment, not to the extent I can't believe, not that we need to compare them, but I would think emotions would be a large component of the family court. What do you see? What do you recommend? What are your thoughts about emotions and how they operate?
Well, I think there's a lot of things that you can do. One is one thing that I see that makes a huge difference is, as I said, in the court, we're working with these very high conflict cases. And oftentimes the judges say, well, you should go talk to the mediators. And, it's mediation is always voluntary. They don't have to. But I have had them go back into court and say, no, we don't want to do it. And go back into the court and the judge says, go talk to the mediator. So sometimes they get sent. And
yes, which we've talked about a little bit because that's an interesting problem in civil. It's sort of the same. Where they can't make you go to mediation, but they say start there.
Right. And I have no problem with that because, they don't have to mediate. They have to understand what mediation is before they turn it down. And what I find is that many times, people come into our process thinking that it won't work for them. What happens is when they sit down and you change the tone in the room, about, okay, what we're doing here is we want to help you hear and understand what's important to each side and then explore ideas to see if there's a way that you can both meet your needs. And slowing it down, taking the time to let them say what they need to say, and they can't say in a courtroom.
Sure.
And have the other person hearing it. And also, communicating back when you restate or reframe that you heard them and then the other person hears it in maybe another neutral way. That whole process of slowing it down and then identifying what, picking it apart a little bit as to, well, so, here's what we heard, what's really important, what do you need, and giving them that space to be involved in that decision making changes things.
Right. So in terms of emotions, then, am I hearing you say it's about structuring?
Structure can help.
The narrative and emotions in a way for clarity? I'm trying to think
I think just the mediation process inherently does that.
Yeah.
It helps, by, and also holding them accountable to the mediation ground rules in terms of being respectful. You know, and there's a fine line because people do need to vent, and sometimes
Yes, they do.
And but gauging what they both need,
Yeah.
and kind of refereeing that, in a boundary that's acceptable to them. And so sometimes, I can have people that are maybe not saying very nice things to each other, but they're okay. They're both okay with that. And
Yeah.
if they're both okay with that, and the mediation is moving forward, I'm okay with that.
Right, which I have always said, it's productivity
Yeah.
that's
Right.
going to matter. It's the progress bar moving along as opposed to...
Right. Is it going somewhere?
Because sometimes mediators, I find, especially early mediators, they'll say, oh, you did swearing, that's bad, or you
Right.
said this one
Yeah.
term and we have to stop the whole mediation over it.
Right.
And what I hear you saying is that overall progress is your
Right.
true allegiance.
Right. Well, that's what you're monitoring as a mediator. Is,
Right.
is what's going on right now in the mediation, is this productive
Yeah.
for them?
Oh, absolutely, for them.
And that's what I'm asking myself. And if not, then what do I need to do as a mediator to step in to make an adjustment?
Right.
But if I feel that it's making progress, then I'm going to let it continue to go. And it varies mediation to mediation.
Oh, yes.
What I find with high conflict couples is that oftentimes I am more of an enforcer, in terms of setting ground rules. Typically in my pre-mediation, speech that I give, I just say that my expectation is that we'll all be respectful to everybody
Sure.
in the room. That's my ground rules. It's very, very minimal.
Very simple.
Okay. If I know for a fact that I have a very contentious, sometimes even like there's a restraining order in place, where and know some history about it where I'm concerned, then I will lay out more specific ground rules. No name calling, no, about what I want it, how I want it to proceed, and then make sure that I call them on it if
Right.
anybody steps over. When I first became a family mediator, I think I was very nervous about
I think everybody is.
dealing with the emotional element, and my role is to keep it under control. And how do I do that?
Sure.
And so I think I typically started out with a lot of ground rules and called people on it, and but that was more a reflection of my lack of confidence
Interesting.
in
Right.
being able to know when I really needed to. I was afraid it
Right.
would get out of control.
But that's sort of also having the experience to know what
Yes.
is productive and unproductive. So you might have initially thought something was unproductive in your earlier days.
Right.
And now you realize maybe with your broader experience that gets them to a place of better
Right.
understanding or elaboration or whatever.
And I think one of the key things I've learned is that it's not for me to figure out.
Yeah.
I just need to ask them.
Right.
Is this being productive? Is this getting you to, what we're trying to focus on today is getting this decision made. Do you feel like this current conversation is moving you there? And then
That's great.
then they, I don't have to make those decisions. I just have to check in with them.
Sure.
And find out, are we on the right track?
Right.
And and most of the time they'll say no if it's not being
Right.
productive.
Right.
And they may end up going right back to it 10 minutes later. But then,
As
wait a minute,
humans do.
we were there a few minutes ago. Is this being
Yeah.
productive? So that's
Yeah.
where for me the skill of the mediator is in just kind of monitoring their interactions.
Yeah.
And are they moving, we've identified what they're trying to accomplish here. And that's another thing that I see lots of times mediators don't do.
Right.
What are we here for?
Right.
And making sure that it's clear and they're here for the same thing. And maybe, particularly in divorce mediation, there can be, a whole laundry list of issues
Sure.
that they need to address. But and they'll keep trying to. Someone will want to speak to something else. But here's what we're doing right now. So that kind of control
Right.
of the process.
Right. And
is-
monitoring.
is
I mean, both,
for
really.
for the mediator to engage in that is very helpful. So really, my focus is on really what is that process, and is this working? And if where we are isn't working, then what do we need to do to change it?
Right.
Yeah.
Now, one question that I haven't ever thought of until this moment, which is, are you mostly mediating in joint session, or do you shuttle when you talked about a restraining order and some different? What's the difference there, or what happens normally?
That's a topic of big dispute amongst family mediators.
Of course it is.
You know, there are some mediators who will only mediate the entire divorce in joint session. They
Okay.
feel that it's inappropriate to have sidebar conversations with one side or the other because this is their process. Then, you know, there are some mediators who really like caucusing.
Yeah.
And then most of the work that they do is in caucus. So I don't think there's a right or wrong way to do it, and I think that oftentimes that's a reflection of the mediator, and that's you know, I know some very good mediators who do almost completely caucus the entire divorce process, and are very effective and very well respected by the litigants who work with them. You know, but that wouldn't be the way I would approach it.
Okay,
No.
so I got to ask you the question that's obvious here. You said it depends on the mediator. Instantly, I thought to myself, should it? So in other words, one of the perspectives I have about mediation is that the disputants and the situation dictate some of the behavioral choices I make, not the other way around. So like just because I like caucusing doesn't mean it's good for them, is I guess where I'm going with that. What do you think about that?
Again, I think it depends on the mediator, because I think some mediators have that ability to be fluid
Okay.
and to move in and out of styles.
Okay.
You know,
Fair
and
enough.
some don't.
Okay. Fair
And
enough.
so then the critical question is, when you're looking at working with a couple, you know, is this, if you don't have that flexibility, is the style that you're going to bring going to suit them?
Interesting.
And if
Okay.
it's not a good fit, you know, more than likely it's not going to work.
Right.
And so that's why, you know, if I were doing, you know, I don't do private mediation on the side. If I were, that would always be where I would start with the couple in terms of talking about, you know, my style of mediation, my approach,
Right.
and, you know, and is it a good fit for them? And I know that there are some, you know, people, because, you know, just people who come in and speak with us in our agency who, you know, they want someone to give them a lot of information and, you know, almost advise them as to what they should do.
Yes, they do, I'm sure.
And so,
Yeah.
you know, but you know, ultimately it's their decision, but I think being as clear as you can about, you know, how you approach it, and
Yeah.
letting them know so that they make the right decision. Because, you know, there are multiple styles of mediation.
Yeah.
And they vary significantly, and there's I don't know why sometimes mediators become so rigid on it has
yeah.
to be this style.
Oh,
which
I
is
think so.
Odd for a mediator to
Yeah.
take that position.
Right.
But you know, I think a lot of it is about a mediator really knowing themselves.
Yeah.
And what are the strengths they bring, and how are they going to construct their process, and then communicating that to the people that they're going to be working with.
And
I
just-
think that's my obligation.
Yeah, just to highlight that idea, so that idea is something that I also agree with, this notion that the mediator has to be pretty in touch with the tendencies that he or she has, the values, the styles, the preferred method, like all those things,
Right.
in order to understand how to navigate that context.
Right.
And to the extent that mediators aren't very self-aware, it would seem to be a dangerous, I guess, element to add to the mediation. Right? To
Right,
be kind of
right.
unaware about how you
Right.
interface with the context of mediation.
Right. And I think having a clear understanding of what your boundaries are as a mediator, and I think that's particularly challenging in family mediation, because oftentimes the topics that they're talking about, like a parenting plan and children, are things that we just intuitively care so much about. You know, and I'm speaking largely to, you know, the people who come and volunteer in our program. They're there because they want to give back, and they want to see people have positive outcomes. They want to see good outcomes for children.
Right.
but I have to remind them that when they're mediating, that is not their role. You know.
Okay. So let's talk about the issue of fairness then. So I am someone who loves things that are fair, and I think you are that way
Yeah.
too. You're kind of built that way, right? What happens when you see unfair and both parties agree to unfair, according to Kathy?
Well, and that's where, you know, and I think that, again, that's something that I have learned, and even my husband gives me some credit for developing that ability.
All right.
Over
Wow.
the 12 years that I've been a mediator to maybe not be as, I am inherently judgmental.
Okay.
But to set that aside. And that's where I think that, you know, that I can do that when I'm a mediator. Maybe it's because I've been doing it as long as I have, that I don't go in thinking about, you know, judging it. It's I want to make sure that they understand what it is and that they feel that it's fair to them. And
So they're fair, not
that
your fair.
Yeah, that it's about their sense of fairness.
Okay.
And, you know, and I might say, you know, so and that's where sometimes I might use a caucus. If I feel that something is blatantly, you know, skewed and it doesn't suit my sense of fairness,
Right.
then I might, you know, meet with each of them and just talk with them about, you know, do they understand where this would go if it was in the court? You know, they're choosing to do something very different, you know, and you know, is that, you know, and it just ask them about how they feel about that, you know, what's their thought about that,
So
and
that-
explore it with them.
That's interesting. So you're caucusing, but again, I didn't hear you saying you're caucusing to say it's unfair. You're caucusing to give it context.
Right.
So to say, here is the worst scenario that might happen in court. Here's the best outcome that might happen in court. Here's the range of possibilities. Here's
Yeah.
the information that you need about the definition of something.
Right.
But it's not like you're saying, therefore it's unfair.
Right.
You're just saying, let me qualify it and make sure you want to still do this
Yeah.
with all that information.
Right, and sometimes there is a challenge where, you know, because there's a power dynamic.
Yeah.
You know, in a long-term relationship.
Sometimes? Isn't there often?
That where you know, one person has more of the power than the other.
Yeah.
And so it's about, you know, that's when I really want to do a check-in, when I feel like, you know, why is this person agreeing to this when you know, maybe I know they could get more
Right.
in court. So exploring with them their ideas about it, and you know, and for example, you know, if it's a property division, they are. I've informed them that what a judge will do basically is look at, you know, the community property, and then by law, the judge has to split it 50-50. So they know that. And so,
Right.
so then if they do with something very different, I can say, you know, so we've had that conversation. You're talking about doing something, and I just want to check with you, you know, to see, you know, why, how you feel about that. The fact that it is different than what would happen in court. Yeah,
Right.
so that's kind of that context of coming back to it.
Okay. All right. So what would you say you've learned about our legal system and about other family mediators?
So our legal system is that it is not the place to start divorce. Because from the get-go, it's, you know, it just makes it adversarial and it makes it contentious, and it does not provide an opportunity for working together. You know, I've done a large number of mediations with attorneys involved.
Right.
And
which
that-
we haven't even talked about yet.
And but sometimes what I'll see is an attorney who, you know, they know the law and they feel their obligation is to get the most they absolutely can for their client based on the law.
Oh, absolutely. I
Okay.
think so many think that.
But that may not be what the client wants. So sometimes I've done mediations between the client and the attorney in caucus.
Okay.
So that, because they're not on the
Yeah.
same page.
Right.
About, you know, because the
Interesting.
attorney is so driven and feels such a sense of obligation to advocate for what they can get according to the law, but that's not what is most important to their client. So you know, there's so I think that that system is a problem, and oftentimes the parties don't even know what's going on in their case. It's a conversation between the attorneys when there's attorneys
In the
involved.
mediation?
No, in the case.
In the case, okay.
In the case. So when we sit down and and I'm open to, I do mediations with or without attorneys based on
Right.
just what everybody feels. Again, mediators, some exclude them, some only do them with them.
Oh, yeah.
Those are decisions to be made.
Right.
But sometimes the parties really have, you can tell they have real no understanding of what's happening in their case. And decisions have been made and
Sure.
judgments have been rendered, and
Right.
and they really don't get it. So that whole system is challenging, I think. And I don't want to badmouth attorneys. There are many attorneys who really do listen to their clients and advocate for what their client wants.
Right.
And I do think there is a shift towards more of that in family law, a recognition that it needs to be approached a little bit differently. So I think that's the biggest challenge I see with the court system.
I hear like this tension between me and we. Like it's like the attorney's saying, no, it's me, it's this one interest, but you're trying to facilitate a we.
Well, and I don't know, but I don't know, from a legal perspective, is that what I could see where they think that is what their role is.
Oh, absolutely. I think, and they're being paid by one person.
Yeah, and so that I don't fault them for that. That's where they're at. It's so try not to be judgmental about it, but that's what you're working with when you have someone
Right.
like that. Yeah.
Interesting. So
Yeah.
tell me what you've learned about other mediators through this process.
So with mediators, I think one of the biggest challenge for family mediators is setting aside your biases. Because as I said, people really you do care about outcomes and about how it affects children. And when parents are fighting so much that every exchange is a nightmare for the children, it's hard not to want to go in there and lecture them about what they need
There's
to do.
children involved. Pay attention.
And I see, and I don't know if this is biased or not, but particularly mothers who, because we have a lot of retirees who, come into our volunteer program.
Oh, mother mediators.
Yeah, mother mediators, yes.
And so
Yes,
are they
wanting
more,
to advocate for the children?
which inherently a mediator shouldn't advocate for anything.
Right. That it's not, it's not about being an advocate for someone when you're being a mediator. So I think that, and people being aware of what their biases are is, so I think, part of that self-discovery of exploring what are your trigger points. For example, one of the biggest challenges for me is when I do have that attorney who wants to take control of my process.
Yeah.
and that's really hard for me to manage my response because I immediately want to, have a battle and get control. But that's not, my role as a mediator either.
Right.
And getting sucked into that.
Interesting.
So lots of times I think, knowing what your weaknesses are and being careful that you don't let it, come out in the mediation is really important.
Right, very interesting.
Yeah.
Do you have a philosophy of mediation, and how does it show up in mediation if you have one?
Again, I think that's something that's really evolved, and I think something that has really impacted that is the kind of some side work that I've done in restorative justice.
Okay.
And so I really look at it, as we discussed a little bit about the fairness, and that when I first started, I wanted them to have fair outcomes. I wanted to, see people get to resolution, those kinds of things when I was early in my mediation career. But now I really look at my role as, an empowerment one, about helping people in, the parties collectively and individually exploring things, what's the best for them.
Right.
And what can they do together. And so one of the things I think that, so more about really paying attention to how they're communicating, what they're saying, and are they hearing each other
Okay.
is really, I think, the thing that I focus on the most in mediation. And that's kind of nice because then that's my job. I don't have to worry about all the,
Right,
is
you're-
it fair, is it?
Yeah, exactly. You're like focused on empowerment.
Yes, it really does simplify it and
Yeah.
take away a lot of, it's not my responsibility.
Right, which
You know,
is
is-
so that's something that we talk about in role definitions, saying that's the gift of role definition, is to say, gosh, I'm actually not responsible for these
Right.
25 things.
Right.
I'm responsible for this.
Yeah.
And this is what I will do today, even though a lot of people like to step out of roles.
Right.
But
Yeah, and I think
It's,
that's why I love mediation so much because actually my father was a judge, and I always thought I could never do that because it's so the responsibility of the decision making.
oh yeah.
But I love the analysis, and
Yeah.
so I get to have fun. I get
You
to
get
do
to
the
have
fun
fun,
part,
yeah.
but I'm not responsible for anything that they decide.
All of the interaction
Yes.
and fun without the responsibility.
Yes.
Yeah.
And that's
I
that's
guess-
what's so great about mediation.
Well, but I guess I challenge one notion there, which I know you'll agree on, but the responsibility of doing the mediation role well.
Absolutely.
That we can't
Absolutely. Yes,
get
yes,
rid of
yes.
as a responsible part, right?
Oh, absolutely. Yes.
So-
And that's not easy. And
No,
that's why
no, no.
that's why I think that,
No.
and it's a work in progress as a mediator. I am still, I've been mediating for 12 years.
Right.
And I am still growing as a mediator and developing and improving my skills. I'm not there yet.
Yeah, and that's
Yeah.
something that we talked about before the show too. This notion that it's not like you become a mediator, now you're good.
Right.
It's this notion that you have now subscribed to this lifelong learning
Right.
job
Right.
that will make you make fewer mistakes or fewer noticeable mistakes, but that you will still make them
Right.
and you'll still grow. And I guess my thought, and I'm 30 years into teaching, higher education, I still feel very much like I have many things to learn, and that in that I refine more thinking, more perspectives, more context every day on my job.
Right. And I think that goes back to the philosophy a little bit in terms of what I see my role is to be a presence in the mediation.
Right.
And I know, and I trust my skills as a mediator. When I first started mediating, I was very, process oriented. Okay, step 1, 2, 3, 4, 5.
Yeah.
Never deviate.
Yes.
Because that
Yes.
gave me the security. Have strong ground rules, and enforce them.
Yes.
But there's an art to it. And I
Yeah.
think as you become
Yeah.
a more experienced mediator, you can move away from being so rigid about, that following that process to more fluid in terms of, what is it that I bring from all of my experience as a mediator that at this moment,
Right.
what can I contribute to help them, move forward in
Right.
their process.
Right.
So that's really, I think, in a nutshell, what my philosophy
Yeah.
is being that presence there. And part of that is about trusting myself.
Oh, yes.
That I can let go of the control, and that what I see and can reflect back is of value to them.
I think I'd add one more layer to what you just said to tie in an earlier concept. You talked about letting go of control, but I don't know that it's all control. It's just
Right.
control of the productive part.
Right.
The unproductive part, I hear you saying you have high control over.
Right. And so maybe
If-
control isn't or.
Oh, I don't need
Yeah,
to challenge
yeah.
that word necessarily. I'm just saying, as I hear there's two different ways to think about that. Because I give up control in that you are able to navigate your solution for your outcomes.
Right.
And I heard a big theme there on what you
Right.
just talked about, right? And being comfortable with that and knowing your part in that and all of that,
Right.
which is really great. And then but I don't hear you saying you give up control when it becomes unproductive.
No, and there also is a very definite structure to mediation.
Yeah,
that,
for sure.
that doesn't go away. Yeah.
No, but
Yeah.
but we have
Yeah.
real people, and as you and I have talked about before,
Right.
I get to the very end and someone says, "Oh, I forgot to tell you about such and
Right.
such," and you're like, "Oh no,
Right.
we're
right.
going to be going back to the very beginning, maybe."
Right.
I mean, we don't know.
No, yeah. Well, and that's what I tell, when I'm working with mediators, that they'll say, "How do you think it's going?" I won't know until it's done. I mean, that, and
Right.
that's my response to them, because
Yeah.
it does.
Right.
There is, my experience has taught me not to set an expectation
Right.
for this mediation is going well or poorly.
Right.
It's just going.
Yeah,
And
we're doing the work.
and you won't know, until you get there, because I have had ones where, at the very last minute, something, I thought, oh, this mediation is going great, and then at the last minute, some point came up, and it just threw the entire thing out.
Yeah, and we've certainly all had that, which
Yeah.
is, wait a minute, you own
Yeah.
the business? It's like,
Yeah.
what?
Yeah.
that changed everything.
Yeah.
Right? Or
Yeah.
you're related to this person or something else. Yeah.
And I think that's one of the, kind of feeding back to the issue about emotions, is that I think sometimes when you try to control those emotions
Yeah.
throughout the mediation process so that you can get to a resolution, many times I've seen situations where that's been done, and then at the end, you can't get somebody to sign
Yeah.
because emotionally they're not there.
Right, and that
Yeah.
control kind of
Yeah.
limited that.
Right,
Role
and so
of emotions.
you could contain it
Yeah.
and push it down, but at the
Interesting,
end,
yeah.
it's if they
You
don't
needed it.
if they haven't gotten there emotionally.
Yeah.
And then too, I also think that I don't feel that it's right for them. If they're not,
Mm-hmm.
I know some mediators who will say, let's get through the mediation. We'll go, 5-6 hours, and then we get them, to sign, and great,
Yeah.
we got a resolution.
Right.
But I'm a little uncomfortable with that, because if they don't feel good about it the next day, and everybody gets tired and worn down, mediator included.
Yeah, yeah.
When you have, not to say that I haven't had some very productive long mediations.
Right.
But
it's hard.
But making sure that that's not happening.
Mm-hmm.
How do you make sure that this really is, going to be something that really does fit well with them. Before they sign off on it. That's
Right.
important to me as a mediator,
It's
to
like
feel like
it's
that.
like the full buy-in.
Yeah, yeah,
Not putting emotion over to the side,
Right.
and then inviting it back in at the last second to say you're good with this,
Right.
But to have it be as present
Right.
as it needs to be, is
Yeah.
that maybe a way to say it?
and and oftentimes emotions can be an impasse that you can't get by. I had a mediation recently where we were going along doing a property division and everything. We were getting things up there, and it was very tedious because they were in a place where they didn't trust each other, and there were a lot of hurt feelings.
Yeah.
And so no, that table is worth $500. No, it's only worth $100. So
Oh,
every
yeah.
little thing, which was
Right.
really more about the emotional issues and the hurts than
Sure.
it was about the value of that table.
Right.
So we were working through that. But then it finally got to the point where I stopped and I said, so, what I'm feeling here is that there's a lot of hurt on both sides.
Yeah.
And there really is a lack of trust that you're coming to this, in a willingness to give.
Right.
And so at this point, I don't know if, it makes sense to move forward in the mediation.
Right.
And so I basically ended it because
Yeah,
emotionally they weren't in a place where they could do it
Right. It's like
Yeah.
too big of a factor.
at that point in time.
Yeah.
That being said, and that's one of the things that you see working in family court with these people who come back repeatedly, I have seen change. And then I tell them that, I've worked with a lot of divorcing couples, and over time, things usually do get better. Become easier
Right.
as you distance it. And lots of times going to court and having a judge make a decision on something,
Yeah.
moves them forward.
Right. Because
And
then
then
that's
they
that.
can come back and mediate other things. Yeah. So it's kind of, there's a lot of moving parts in the
Yeah, but that was interesting about saying the table, is it worth 100 or 500, and not being able to navigate it. And to your point that if you didn't, so you talked about emotion and really addressing the emotional component of that. To your point, if that mediator gets rid of it entirely, that deciding the table's worth 200 doesn't do anything.
Right, and then more than likely, my experience is that mediation is going to fall apart at the end.
Right.
Yeah.
Because it
You know,
won't work.
you got them to focus, you controlled it, you got them to focus on getting things done. It's done, but somebody's going to balk.
Yeah, very interesting. Okay, so last question for you. I have a number of people watching the show who may be interested in family mediation or getting started in that. What is your advice to someone starting out as a family mediator?
I think, getting the background, whether, and it's a combination, you can get it through books, you can get it through trainings, you can get it, finding somebody that you can work with that's already doing it is absolutely the best way to approach it. I think the biggest challenge to doing family mediation is building the business.
Okay.
So, no matter how good a mediator you are, if you can't get clients,
right,
then that's the biggest challenge. So doing what you need to do on that end as well.
Okay.
Learning about how to market a business, how to, start building it.
Right.
And is equally, and I don't, not more important in terms of
no,
but in terms of succeeding
sure
as a mediator in family law right now, I think that's where it is. Hopefully my hope is that it will change over time, and that will be more people will start looking for mediation at the beginning of a divorce rather than.
I hear that more than ever, but I'm not a practitioner in the field, but I do get requests frequently, that I would refer.
It's more, I think that, and more, just recently I've started to see more of that, but there's still just an awful lot of people who think mediation is arbitration. And
yeah, they sure do.
Yeah.
Or something else.
So, that's a challenge.
Yeah. Well, Kathy, thank you so much for being here today. It was great to learn about your experience, and we really appreciate you taking the time to help us understand. And that concludes our episode for today. My special thanks to Kathy Shimizu for joining us on our show today and for teaching us more about family mediation. As all of us think about this process of mediation, of course, we could pay attention to the context that we're in. And I think we've learned, especially today, that all of the contexts that we do mediation in have different demands in terms of practical knowledge and logistics. But the mediation part is the same. And we hear a lot of same themes about neutrality and understanding roles, and being very well acquainted with strengths and weaknesses of yourself as a mediator, your areas of growth. And as you become progressively aware of all of those things, then we all can be on that path of learning in the mediation process. Of course, one thing we've talked about today is this notion that when you and I act as mediators, we are never to the place where we say, gosh, I'm a mediator, I'm good now. Instead, we really have the notion that I'm on the path, and I have skills, and I'm ready to learn new skills and ready to learn new contexts and new challenges as I try to help people. Of course, you know my bias about all of it, and that is we can have all the knowledge in the world, but if we're not helping real people out there, we have to examine our motives and kind of where we stand in terms of purpose. And so I leave you with that, to think about your purpose and to also think about your skills and the role that you play in order to help people get to a better place. Well, that concludes our episode. Have a great day.